Coming to you from the Forge of Freedom studio in the heart of America. A podcast dedicated to preserving freedom and inspiring personal success. Freedom is born and lives through you, the individual, and it dies in the shadows of tyranny. Motivating our listeners to become well-rounded, freedom-minded people with the body of an athlete, the mind of a stoic, and the spirit of a warrior. The tree of liberty lives on through you, the Forge of Freedom. And now here's your host, Alex Ooley.
Hello, everyone, and welcome to another edition of the Forge of Freedom podcast. I'm your host, Alex Ooley, and this is episode 42 of the Forge of Freedom. Today, I want to talk to you a little bit about a case that has vastly expanded federal government power. And this is not a new case. This is a case from the 1940s. And it's a case that prior to law school, I had never heard of. But when I read it in law school, I distinctly remember that not only did I feel like it was an unjust result, I thought it was a terrible outcome for limited government and for personal liberty. And so I want to share it with you today because I think it's one that you've probably heard of if you've read or listened to the Supreme Court or many of their opinions about the Commerce Clause. You've probably heard about the Commerce Clause in the media. But the case is called Wickard v. Filburn. And before we get into the case, I just want to talk a little bit about some background. And I first want to share a quote with you. It's one of my favorite quotes from the Federalist Papers, and it's from James Madison, and it says this: "If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men, over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself." And I think that was really the problem that the founders were grappling with. The central problem was this: if people aren't good enough to govern themselves such that we require government, how can we trust people to govern others through the mechanism of government? And that's a problem they dealt with, and they tried to solve through a notion that we've all heard about, or should have heard about if you were taught government in high school or civics, and that's the notion of the separation of powers. And this separation of powers was intended to be a control on the government so that the government would have internal controls on its authority. And the government was divided basically into three separate and distinct parts. The Congress was given the authority, the power to make the law, and the authority of Congress is set out in Article 1, Section 8, the powers of Congress, and I'll talk about those more in just a little bit. The executive branch was given the power to enforce the laws, and then the judicial branch was given the authority to resolve cases, to interpret the law. And we're going to be talking primarily today about the Congress, congressional authority, congressional power, and the judicial branch, the judicial authority. And in Federalist 58, and this is ironic because Federalist 58 was written by Alexander Hamilton, and he's ironically one of the most big government, quote unquote, of our founding fathers. But Hamilton had this to say about the courts, and I'm going to share a few quotes with you from Federalist 58. He says, "Courts of justice are to be considered as the bulwarks of a limited constitution against legislative encroachments. A limited constitution can be preserved in practice no other way than through the medium of courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. Without this, all the reservations of particular rights or privileges would amount to nothing. The courts were designed to keep the legislature within the limits assigned to their authority. Where the will of the legislature, declared in its statutes, stands in opposition to that of the people declared in the Constitution, the judges ought to be governed by the latter rather than the former. No legislative act, therefore, contrary to the Constitution, can be valid. To deny this would be to affirm that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. It will be the duty of the judicial tribunals to guard the Constitution and the rights of individuals. So there you have it. Here, Alexander Hamilton, one of the biggest government advocates, one of the biggest advocates for a central government, is talking about the essential component of the judiciary in limiting the authority of the legislature to its enumerated powers, specific, limited powers. And keep in mind, too, that I've discussed a couple of quotes here from the Federalist Papers. The Federalist Papers were written to try to sell the Constitution to the states because to ratify the Constitution, there had to be enough public support and enough support from the states. And these Federalist Papers were designed to sell the Constitution. And they were selling a Constitution of limited government. So, as I mentioned earlier, the Constitution establishes a government with very specific and limited powers given to Congress outlined in Article 1, Section 8. And these enumerated powers restrict the federal government to only engage in activities explicitly mentioned in the Constitution. The list of powers granted to Congress is concise. Congress can borrow money, coin money, regulate its value, and punish counterfeiters. Congress can regulate commerce with foreign nations, among the states, and with Indian tribes. Congress can establish rules for naturalization and bankruptcy. Congress can establish post offices and post roads. Congress can issue patents and copyrights. Congress can establish courts inferior to the Supreme Court. Congress can punish pirates. Congress can suppress insurrection, repel invasions, declare war, raise an army, maintain a navy, and make rules for the army and navy. And finally, the Congress can organize the militia, leaving the states the appointment of officers and the authority of training the militias. And that's it. This is all the Constitution permits the federal government to do. So why do I give all this background and this lead up to the podcast topic of the day, Wickard v. Filburn, this Supreme Court case from 1942? Well, I think it's important to keep these notions, the separation of powers and these specifically enumerated and limited powers in mind. And also the role of the court in limiting the legislature to its enumerated authority. Consider, for instance, the United States experiment with prohibition, which was enacted almost 100 years ago, nowhere in Article 1, Section 8 powers does one see the authority to ban the manufacture, transport, or sale of alcohol within the United States. And so when Americans decided that they wanted to ban alcohol, they amended the Constitution to give the federal government this authority, because the federal government did not have that authority except through a constitutional amendment. 14 years later, Americans came to their senses and revoked this authority by amending the Constitution again. The 21st Amendment was, in fact, the only amendment ever ratified for the purpose of undoing a previous amendment. But amending the Constitution is a very difficult task, and it demonstrates this prohibition experiment demonstrates that the government thought that the federal government had limited powers, and that to prohibit the manufacture, sale, or transport of alcohol, they had to amend the Constitution. This historical example of prohibition demonstrates how amendments were required to grant the federal government additional powers. And until 1933, when the 21st Amendment was ratified, repealing prohibition, the United States maintained, for the most part, a constitutionally limited federal government. This framework aimed to decentralize governance, giving states the majority of the governing authority. And remember, think back to the Federalist Papers. The states wanted to maintain autonomy, and they never would have agreed to the Constitution if the Constitution usurped state governing authority. Why would the states agree to give up their governing power? Each state could govern differently, creating a large-scale experiment in democracy. States that governed effectively would attract business and people to live there, while poorly governed states faced losses in these areas. And this system was really a laboratory of democracy, a laboratory of governance that paralleled in some ways a market competition between states and the way that these states would govern their citizens. However, a significant issue emerged after 1933, after the repeal of prohibition, and there was really this turn toward a more authoritative, a more powerful central federal government. And it all has to do with the interpretation of the commerce power under Article 1, Section 8. Remember, I listed those powers that the federal government has under Article 1, Section 8. Congress can regulate commerce with foreign nations, among the states, and with Indian tribes. And this commerce power was the central component of the Wickard v. Filburn case. And the problem was the ideal that was envisioned by the founders, that the judiciary, as I talked about in those quotes from Alexander Hamilton, would limit the legislature to its constitutional bounds. That ideal was not upheld. And that's illustrated by Wickard v. Filburn here. The institution, the judiciary, that ended up deciding what federal government is empowered to do is itself a branch of the federal government. And I think that was a fundamental, I think the founding fathers were brilliant, but I think this was a fundamental flaw with their vision. And it should come as no surprise that when push comes to shove, the Supreme Court routinely finds in favor of empowering the federal government. And this sort of mischief began really right after, like I said, the end of Prohibition, and with the FDR administration. And in 1942, the Supreme Court decided the case of Wickard v. Filburn, in which Roscoe Filburn ran afoul of a federal law that limited how much wheat he was allowed to grow. The federal government under Roosevelt decided to limit the production of certain crops, such as wheat, to stabilize the supply and the price of these crops. By reducing the supply, they could prop up the price. It's a simple supply-demand proposition. And the goal was really to prop up, it was an early form of crony capitalism, to prop up these farmers, these large farmers who had political sway, who had a lobbying influence, so that you could prop up the price of their crops. And if someone grew too much wheat, they would be fined for doing so. And an Ohio farmer named Roscoe Filburn was accused of violating this law by growing too much wheat on his property. And a careful reader, and if you've been listening up to this point, might ask, where does the federal government's right to legislate the wheat market come from? Where is that power found? It wasn't in any of those powers that I read off in Article 1, Section 8, surely, because the word wheat is nowhere to be found in the Constitution. But that as it may, the federal government's aim was clear enough. It was to keep the price of wheat high enough for this lobbying contingent of farmers. And this law that limited the growing of wheat was called the Agricultural Adjustment Act of 1938. And the question that the Supreme Court was presented with, in this case brought by Roscoe Filburn after he was fined for growing too much wheat, was whether the federal government could regulate his wheat production under the Constitution's Interstate Commerce Clause, even though the wheat he grew never actually entered interstate commerce. The regulators enforcing the law said yes, that the federal government does have the power to regulate this activity. And the court, ultimately, the Supreme Court, agreed. Now, Roscoe, what's important to point out is that Filburn never sold the wheat at issue. He was consuming the wheat, the excess wheat he was growing on his own farm, feeding it to his own livestock. So how could this implicate interstate commerce if it never left his property? He never sold it across state lines. So despite Filburn's non-commercial use of this excess wheat, the Supreme Court deemed it interstate commerce due to the hypothetical impact on the market. And this ruling effectively expanded the definition of interstate commerce, enabling Congress to justify exercising authority that was not explicitly authorized by the Constitution. And since Wickard, whenever Congress sought to exert power beyond its constitutional boundaries, it simply had to establish a connection to interstate commerce. And consequently, numerous federal agencies, programs, and initiatives were established, some with genuine interstate commerce involvement, but many without. And over time, after Wickard, the interpretation of the Constitution shifted from one that limited government power to one that empowered the federal government. So this just struck me as ludicrous. I mean, here Roscoe Filburn is growing wheat on his own property, consuming that wheat on his own property, never actually selling the wheat And the federal government says we can regulate that activity under the Interstate Commerce Clause, under the Commerce Clause of the Constitution. Hypothetically, or theoretically rather, that gives the federal government almost unlimited power to regulate any activity. My sitting around doing nothing, although minuscule, affects interstate commerce. My consumption of, the water off of my own property could affect interstate commerce because it prevents me from having to buy water off the shelves at Walmart. So it's just this very expansive view of what was supposed to be very limited and enumerated powers. So not only did the judiciary fail to limit the federal government, as Alexander Hamilton thought we should do, the judiciary expanded the power of Congress and the federal government. What's interesting, too, is at the time, even the New York Times, which is generally bad on issues like this, generally in favor of an expansive view of government power, questioned the decision and this expansive view of federal authority. The New York Times said, if the farmer who grows feed for consumption on his own farm competes with commerce, would not the housewife who makes herself a dress do so equally? The net of the ruling, in short, seems to be that Congress can regulate every form of economic activity if it so decides. About 15 years ago, William Meller and Robert Levy co-authored a revealing book called The Dirty Dozen: How 12 Supreme Court Cases Radically Expanded Government and Eroded Freedom. The Wickard case is among these nefarious decisions they zeroed in on, and I think deservedly so. In his foreword to the book, Richard A. Epstein opines, by extending federal regulatory authority to nearly every productive economic activity, Wickard eviscerated the principle that the federal government has only those powers expressly granted to it in the Constitution. And for this reason, to sustain an ill-conceived cartel whose chief purpose was to keep the domestic price of wheat close to 3 times the world price. I share this with you because if we want to maintain our freedom, if we want to live in a world where we are free to utilize our own property, to provide for our own survival, and to freely exchange with those around us, we have to return to a government and a world where government is restrained to its proper role. Unfortunately, we're far from that, but it's not over. We have the ability to put government in its place, to restrain it, and to preserve the liberties that we do have. And I think the first step in all of this to address this problem is to read, understand, and apply the Constitution of the United States. It's crucial to recognize that the legislative function is the responsibility of Congress alone, and to take Article 1, Section 8 seriously. Restoring limits to government power is essential for preserving individual rights and restoring balance to the system. if the courts do not take do not take constitutional law seriously, do not take their role in limiting the federal government seriously, then the limits imposed by the Constitution are already a dead letter. It is no more than what James Madison called a mere parchment barrier that fails to protect Americans' rights. So I hope you learned something. This case, like I said, when I learned about this case in law school, I thought surely it was a fiction. How could the court endorse and uphold federal government involvement in the production of wheat and the consumption of wheat on one's own property? And I think this case set the stage for the expansion of government power for years to come. And there's been very little to roll back that expansion. So to start rolling back the government, to start restraining the government, we have to know where the government authority comes from and how to rein it in. And I think that this case, understanding this case and the flaws with it, goes a long way to doing that. So I thank everybody for tuning in. I hope you enjoyed the show. And if you did, don't forget to like and subscribe. Stay tuned. Obviously, we're going to have a Monday Gun Day episode with Mike Ooley back on the show this coming Monday. But then next week, next Friday, I'll be releasing an episode about the anti-commandeering doctrine in a case called Prince versus United States. And that case was argued by Stephen Hallbrook, who I'll be having on as a guest in a couple of weeks. So I hope you'll stay tuned for that. He wrote the book about the AR-15. It's called America's Rifle. And I'll have him on the show to discuss his book. So I look forward to that, and I look forward to having him on the show. I hope you'll keep an eye out for that as well. Until next time, remember, you are the Forge of Freedom.
Thanks for listening to this episode of Forge of Freedom. Be sure to subscribe wherever you heard this podcast so you never miss a future episode. For more information or to connect with Alex, you can go to forgeoffreedom.com or follow him on Twitter @ForgeOfFreedom. Until next time, remember, you are the Forge of Freedom.